Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Puja Patel, and today's episode is entitled, What Has Happened to Merger Control in India? The Impact of the September 2024 Changes. Some pretty transformative changes to Indian merger control law. And we are here today to give you the full breakdown of these changes and how they'll impact your deals. My co-host today is Matthew Hall. Hello, Matthew.
Hi, Puja.
And can you tell us a little bit about our guest today?
Sure. Our guest today is Nisha Kaur Uberoi. Nisha is a partner and competition law chair at law firm JSA, based in Mumbai. She specializes in all aspects of Indian competition law, including cartel enforcement, abuse of dominance, leniency applications, merger control, competition law audit, and compliance. She represents clients before the CCI, the Competition Commission of India, the Indian National Company Law Appellate Tribunal, and the Supreme Court of India. Hello, Nisha, and welcome to the show.
Thanks, Matthew. Puja, delighted to be here.
Well, thank you for joining us. India is, of course, a key merger control jurisdiction worldwide. There's a mandatory and suspensory filing regime. And as Puja mentioned, some very important changes to the Competition Act 2002, which sets out the merger control regime, came into force on 10 September 2024, which I think many, if not most commentators, have described as the biggest overhaul ever of Indian merger control. I know, Nisha, you've described it as expansive, with some positives and some flip sides or some negatives. Probably the most high-profile change is the introduction of a deal value threshold, or DVT, catching additional transactions in addition to the existing thresholds. But Nisha, before we consider some of these specific changes, it will be interesting to hear your thoughts generally on the CCI's current enforcement under the existing merger control rules, and just a couple of examples of cases that our listeners may have followed or heard about before the CCI.
So the CCI's had a stellar track record on merger control. 13 years in, there have been no blocked deals, 1,107 approved deals, of which there have been 46 remedies, 14 structural, and 32 behavioral. They've been pretty strict on gun jumping. We've had 60 cases of gun jumping, and they've unwound one transaction which was notified to the CCI, where the CCI was of the view that the transaction was not notified in entirety. The gun jumping penalties at its highest is USD 22 million. The CCI has been at the forefront of some merger control developments, including interlocking directorates, in fact, ahead of the US on that one. They first identified and dealt with the issue when ChrisCap was investing a 3% stake in a pharmaceutical company. And at that stage, the CCI asked for the interlocking directorate to be removed. And the person who was common across two different boards had to step off for a cool-off position. The other very interesting case that the CCI had been at the forefront of has been in terms of phase 2. We've only had 8 phase 2 reviews, 7 of which had divestitures. The 8th, which was Schneider's acquisition of a local Indian conglomerate, L&T's electrical and automation business, which had market shares ranging from 40 to 60%, had purely behavioral novel remedies, which are still ongoing from 2018. So that was one of the CCI's very novel remedies very early in the game, when they showed that they're nimble enough, that they will deal with the sector and the merger on its merits, as opposed to having a one-size-fits-all approach and just adopting pure play divestitures.
That's a very interesting summary, Nisha. Particularly jumping out at me was the number of gun jumping cases and leading their way on interlocking directorates and also those remedies. Looking at the amendments which we are going to be discussing today, before we dive into the detail, could you just give us some indication of the importance of these changes? Will more deals be caught? Will the substantive review change? How does it look like at a high level?
So the amendments are a mixed bag for industry. Will there be more merger notifications? The answer is definitely yes. The reason for the enhanced merger notifications is effectively threefold. The first is the Competition Act itself, which has gone through Parliament, amends the definition of control. We move away from the old decisive influence standard to adopt what the UK CMA has, which is the material influence standard. That in and of itself will now result in greater number of merger notifications. It will particularly impact private equity and minority acquisitions. Outside of that, India, unlike the US and the EU, does not have the ability to look at non-reportable mergers, and hence the introduction of the deal value threshold. When the deal value threshold was initially proposed, it was mooted more for digital mergers, but today, when it was introduced on the 10th of September 2024, it now applies across the board to both traditional industry as well as digital economy. And our threshold now is 2,000 crores Indian rupees, which basically is about 239 million US dollars. Still significantly higher than what the US has under the HSR. The target should have 10% of its global GMV originating out of India and 500 crore Indian rupees, which is again 60 million USD. Or if it's a digital services company, it should have 10% of its global users in India. Now, with this, on an overall basis, there exists another set of 8 rules in terms of how the deal value threshold is to be computed. Interestingly, it's going to be computed across a 4-year period. Right? 2 years prior to the date of your acquisition or your merger, if as part of the acquirer group, you have invested in the target, that will stand aggregated towards the 2,000 crore deal value threshold. If 2 years post-completion, you enter into any ancillary agreements by whatever name called, whether these are employment agreements, special founder rights, non-compete fees, tech transfers, technology collaborations, IPR, licensing and the like, all of those will stand computed. If you've got options which are convertible at a much later stage, they will be treated as if converted now. If you're doing an open offer, the assumption is that it will stand aggregated as if the entire open offer is being subscribed. If you've got any future events in your deal documents, all of that will be aggregated today. For those of us like me who became lawyers because we don't like math, we have a no math clause which says if you can't figure out what it's tantamounting to, please assume that you do cross the 2,000 crore threshold and go ahead and file. Right? So that's how our deal value threshold is going to operate. It will obviously capture anything and everything under the sun. Pharmaceutical companies, yes. Molecules, yes. Power companies which were exempt earlier because they didn't have turnover will now be caught. Obviously, it will catch all of the so-called digital killer acquisitions as well. It will operate in the alternate to the old target exemption, which effectively stands negated.
And Nisha, interesting on sort of the implications for more filings, it sounds like, but I'm curious, are there any changes to the way the competition authority will look at deals or, the substantive analysis they'll use to review deals?
So the substantive analysis will remain the same, Puja, because they will still look at all of the theories of harm that they've been looking at and what the global regulators are looking at as well, including the newer theories of harm when it comes to innovation, ecosystems, and the like. What has changed, though, and positively, is the review periods have been shortened on paper at least. Now, the CCI has had a tremendous scorecard when it comes to ensuring that mergers are actually cleared well ahead of the timeline. We'd computed the numbers for the last 4 years. And under the old regime, the CCI had 30 working days and they would, on an average, turn in approvals within 19.4 working days. Now that 30 working days has been reduced to 30 calendar days, which is a bit of a problem because there are 8 exclusions to this. And the size of the merger control department is very small, so they need a lot more capacity enhancement immediately to be able to maintain their stellar track record. Apart from this, when it comes to phase 2 reviews, those used to be 210 calendar days under the old regime. Now that's reduced to 150 calendar days with the requisite exclusions. It's split effectively into 3 phases where there is a show cause notice, there is a proposal for modifications, there's remedies around this, and a statement of objections. So that's going to be the new phase 2 merger review. And our last phase 2, like I mentioned, was in 2018. So far the CCI has not really taken anything to a phase 2 in the last 6 years. On the positive side for industry, since Matthew did pick up on the gun jumping, it was an industry bugbear that if you were doing an open offer of a listed company and you were acquiring on the exchange before you made the open offer, that the smaller acquisitions on the floor of the exchange were treated as consummation of a notifiable transaction and attracted gun jumping penalty. Now we have a standstill obligation in place, which is great because it will impact listed company acquisitions very positively. There will be no gun jumping which will be initiated if you file within 30 days of your first acquisition and you ensure that you do not vote unless it is for liquidation preference or there is an insolvency event. No other voting rights. Your voting rights will be suspended. And with that, then there will be no gun jumping. You can go ahead, part consummate, and then notify the rest of the transaction.
Nisha, you mentioned there the de minimis exemption for the target. In my experience, many transactions are exempted by those rules, certainly that I've looked at in the past. You also mentioned that it doesn't apply where the DVT, the deal value threshold, applies. Can you just explain what's happened with the de minimis exemption in this new legislation and also why you say that it stands negated by the DVT when the DVT, of course, only applies to certain types of transactions and transaction values?
So the target exemption was not codified in our law. When merger control came about from the 1st of June 2011, the government, by way of a notification, had thrice extended the target exemption for industry to benefit and to ensure that regulatory resources are conserved and not wasted on smaller acquisitions. Now that has been codified as part of the law, so it will remain in the law for perpetuity unless it is revoked subsequently. And that's been the first change. When you're looking at the notifiable transaction in India, you first start with the target exemption, where you look at the target, its divisions, units, and subsidiaries to see if it has either 450 crores of asset in India or 1,250 crores of turnover in India. If you're under one of those thresholds, in the old regime, you were exempt. No merger control, you can walk away in peace. Now, even if you qualify for the target exemption, if your deal value threshold, irrespective of sector, irrespective of industry, irrespective of whether it's a global acquisition or a pure play local acquisition, is 2,000 crores, which is 239 million US dollars or more, then you are automatically caught under the Indian merger control net. And if other thresholds are crossed and no other exemptions are available, you will now have to notify. So that's how the DDT will operate as an alternate to the target exemption.
That's clear. Nisha, let's look at the DVT for a moment. You've made some comments already about it. One thing that really jumped out at me was this point about the 4-year period. The 2 years before you can somewhat understand. The 2 years after, in particular in relation, for example, to options being taken up that maybe need to be valued at a later point, or I guess you mentioned licensing as well, which I guess would only be relevant where it wasn't a full acquisition. But how do you, presumably, you've been thinking about how you deal with this kind of thing in practice. Do you need to have some kind of ongoing kind of review every few months to see what's happened, or how is this going to work in practice?
Matthew, that's a great question. I think firstly, in practice, there are going to be a lot of interpretational challenges until the dust settles. People will go and avail of pre-filing consultations with the Competition Commission of India a lot more. And we will also have a situation where, from a DDT perspective, all deals in terms of early documents will have to be assessed very, very carefully, right? Because what will happen is the intent of, let's say, a private equity player, if you're looking at the IC documents, the investment committee documents, and if they say, okay, why don't we try and take a 2% stake now and possibly ramp up to 12, right? The regulator has the wherewithal to commission that IC documents, and then the private equity player cannot say that, look, this is a future contingent event which may or may not happen, because you've gone in and you've said this in your IC minutes, and irrespective of the fact that you had that option to exercise, and which you might never end up exercising, and that option could be a 6-year option, it will now stand aggregated upfront. The trick, though, is going to be to convince the commission not just to aggregate it upfront for assessment purposes, right, but to also give you approval upfront for the option as if it is converted today. Because in our experience, when it tends to be an option of more than 5 years, typically they will say that, look, market structure changes. Why don't you come back the point of time before you exercise that option, right? In which case, it's going to be very ironic that it's going to be aggregated for notifiability purposes, but it is not going to be assessed for the option. It will only be assessed for your initial investment.
Yeah, you want to avoid giving them a second bite of the cherry, I guess. Has the CCI pointed, or has commentators pointed to some transactions which they think were missed as a result of the DVT not being in place? I mean, there's some famous examples before the Commission or the US authorities, but has there anything been mentioned specifically in relation to India?
So Facebook, WhatsApp, definitely one of them, right? And people did write into the commission at that point of time. But like I said, India does not have the ability to look at non-reportable mergers. The second one was in the midst of COVID. In India, we had 2 multiplexes where we could see our movies. There was PVR and there was Inox. And because it was COVID, and these were our 2 largest multiplexes, and at that point of time with the shutdown, the turnover was very, very negligible. They merged, right? So it was literally a 2-to-1, which the commission then couldn't touch. Again, someone went and complained to the commission, but they couldn't pick that up. It would have been picked up today under deal value threshold for sure. And then we've got one of our largest food delivery aggregators called Zomato, which recently picked up Blinkit, quick commerce, right? Which crosses the deal value threshold, but they did it before the DVT was announced and must have availed of the target exemption, right? So we've got a fair few of these which are in public domain and a lot of them which are not in public domain. And therefore the DVT from a commission's perspective makes sense.
Okay, that's interesting. I think particularly your cinema example showing, you made the comment right at the beginning that this is a sector agnostic threshold,
right.
So catching even a multiplex transaction potentially. Let's look, you mentioned as one of the key changes as well, Nisha, the change to the standard of control and the introduction of the material influence test. Could you give, and you referred to the UK CMA precedent here, can you give us just a bit more detail on that? What is the current position? And my understanding to some extent was that material influence was already being used kind of de facto. So what is the current situation, and what do you think it's gonna mean specifically on the material influence threshold?
So until the new amendments came into effect, we had the old decisive influence standard, for which you basically look at either positive control or negative control. Negative control, of course, came about by virtue of veto rights And for us, we had this standard set of 6 veto rights. If you have a veto over annual business plan, budget, appointment or removal of key managerial personnel, taking of any investment decisions, entry or exit into lines of business, and amendments to the memorandum and articles of the company, any one of these 6, it didn't matter whether you had a 1% stake or 2% stake. In fact, the lowest notification has been at 0.17% stake with one of these rights. You would be in control, right? Across the 12 years before this amendment came in, the decisive influence standard was applied, and only in 2 isolated instances, the material influence standard was applied, including in one instance where it was a single board seat, where they didn't look at the numerical value of the board seat, but they said the status of the person involved, and that's under challenge in the courts. We're acting on that one because that was not the standard when the commission enforced it. And now what the commission has done, and it's gone through parliament, control means controlling the affairs or management of the company or the ability to take strategic commercial decisions which amount to material influence, right? That's what the definition says. There are no other guardrails in there. The CCI will, over time, come out with precedents and hopefully FAQs in terms of how they're going to assess this. But for now, this is all that exists. Control, therefore, will still continue to be de facto, de jure. It will continue to be positive. It will continue to be negative. But now there is also this plus factor of material influence, for which, Matthew, we're going to have to look at your jurisdiction to see how the CMA is looking at it for some precedent value.
And has the CMA or the UK position specifically been identified, maybe in parliamentary discussions or whatever, as being relevant, or is that they've just adopted the language and it happens to be the same?
So I was part of the committee for law review, which looked at the overarching changes before the amendments happened. And this was in 2018, 2019, right? We did look across the board, and the UK CMA was what the commission then ultimately decided ought to be the standard. And like you mentioned, there was a lot of discussion and debate around it, whether it already existed in the then old item 1 exemption, which said even if you have 1 board seat, right, is that material influence or not, as opposed to the status of a person, right? So they decided that decisive influence does not work. They will go with material influence. Decisive influence already was a pretty low standard, to the extent that we've got, from an M&A perspective, not a merger control perspective, an anomaly in India, which has now gotten even worse because our corporate law definition of control, our takeover code definition of control, our foreign direct investment definition of control are all in sync. It is only now the competition definition of control, which is much, much, much lower. And therefore, we will have situations, private equity or otherwise, where PL will be in control for competition law purposes only, but may not have to make an open offer, for example.
Unfortunately, that last point you're making is probably not uncommon across jurisdictions. You have different thresholds for different regimes. Nisha, you referred earlier as well to the timeline and procedure changes. And you also referred to use by the CCI of remedies. I was interested in particular about your reference to remedies. I understand that the use of remedies has now been codified. There's a specific format for this. Can you just give us a bit more detail on how the remedy changes, what the remedy changes are, and how these might affect matters in India?
So the remedy changes are actually one of the very welcome moves for industry. They will save a lot of time and acquisition financing costs because of shorter reviews. The reason is this: under the old regime before the amendments, the CCI did not have the ability in law to be able to impose or recommend remedies in phase 1. It was for the parties to voluntarily offer remedies. Now that has changed. The CCI in phase 1 itself has the ability to tell parties upfront what they want, right? So that will save a lot of remedy negotiation time, and hopefully it will save people going into a phase 2. And the second thing that has now come about with the amendments is that the CCI can actually accept remedies even before it forms a prima facie opinion, right? And it's got 30 calendar days to form the prima facie opinion, which is wonderful for global deals where you know upfront that there's certain common assets that you want to sell to a common buyer globally. Then it means that, again, from an overall global deal perspective, India is going to turn around very, very quickly. So this is a very welcome move.
Indeed, that sounds very, very good idea. I mean, I know that the CCI has really not been one of the slower authorities worldwide anyway. So it's good to see that the regime is hopefully going to carry on down that type of route. I understand is changes to the definition of affiliates and overlaps and its impact on both the general filing of a transaction and also on the use of the green channel route for certain types of transactions. What's happened there, and is it going to have any impact in practice?
So the green channel is probably the first of its kind in the world, where for a mandatory suspensory regime, we now have the ability, which has been exercised, I think, in about almost a quarter of our notifiable cases since 2019, where if you have no overlaps, no horizontal, no vertical, no complementary, then on the day you file your short form, you will get an acknowledgement, and that acknowledgement is deemed approval. There is absolutely no wait time involved, right? But of course, the precursor to this is you need the combination division's buy-in that you qualify for the green channel, because otherwise there will be gun jumping consequences, and that pre-filing consultation can take a little bit of time. Now, what the Commission has codified with the rules is that they've made it very clear that to avail of no overlaps, you need to go all the way up to the ultimate acquiring entity. You can't stop at an intermediate level and say, okay, this is it. Let's stop at an Asia fund and not go all the way up to the US and say we don't have overlaps and let's do a green channel, right? So that has been codified and clarified very clearly in the amendments. And the second thing they've done, which is the definition of affiliates, which under the old regime used to be the old materiality threshold, has changed, unfortunately, for the worse. 2 of the 3 limbs remain the same. The first is if you have 10% or more shareholding or voting rights, then obviously you need to look into it. Second, if you have a board seat or a board observer, then obviously you need to map it for overlaps. And the third aspect, because these all operate on an or basis, in the old regime, it was if you have rights outside of an ordinary shareholder, which used to be the old 6 control rights, which I've mentioned, those then need to be captured as an affiliate. Now they've done away with that, and they've said if you have access to commercially sensitive information, then you will need to map overlaps and you will not be exempt, right? And this is also where there's going to be a lot more merger notifications, because there is absolutely no private equity player or financial investor who's going to take a stake in a company without basic information access rights. These could be quarterly reports, they could be monthly unaudited financials. These now will qualify as commercially sensitive information, which has not been defined, and again will hopefully come about by way of FAQs.
Okay, so I mean, it's probably a bit surprising that the first issue you mentioned there, not going up to the ultimate acquiring entity, was not already in place, because that's, my experience, standard. You need always to go up to the top.
It's standard, I agree with you, and it would in the event of group, but I think this time that they wanted to make it very sure and clarify with the use of that specific term, as opposed to just saying group and give the group limbs.
There are other transactions not subject to approval. Is there anything interesting in there and that we should note in terms of changes?
If you're acquiring less than 10%, if you don't have control, you don't have a board seat or a board observer, you don't have access to commercially sensitive information, but you do have overlaps, right? Let's say you're a private equity player taking a 7% stake in pharmaceutical company B. You already have a 3% stake in pharmaceutical company A. Under the old regime, that would be a strategic repeat investment you'd have to notify. But now, if you don't have control, no CSI, no board seat or board observer, but you have the overlap and you're under 10%, you're exempt. So that's the good news.
Nisha, before we sort of switch gears, I wanted to ask one more question, sort of closing out the substantive chat. If you want, there's one takeaway that you'd like practitioners around the world to keep in mind from this conversation on these changes, what would it be?
I would say watch out for deal value threshold more than any of the other changes, because everyone around the world now is so used to doing the target exemption that you will assume that with the target exemption you're home and that the local nexus must be higher than you think it is. That might not be the case, given that the CCI has got literally every permutation and combination possible in terms of the applicability of the deal value threshold. So that's the one to watch out for.
Great, thank you. And thank you for all of your insights today. It's been incredibly helpful. Switching gears, we want to hear more about you, Nisha. Could you share with the audience one fun fact about yourself?
I'm a Harry Potter fan, and I have a 9-year-old godchild. Her parents, who are very close friends, don't understand the Harry Potter world, so we have a lot of fun with this. I, in fact, have Hedwig sitting on my office table.
Great to know that it's not just a U.S. phenomenon. Well, okay, Nisha, we're going to move on to a segment which we call Our Curious Hats.
And now it's time for the Curious Hat.
So the question I have for you is, if you were given $50,000 or 4.2 million rupees on the condition that you had to spend it all in 1 hour, what would you buy?
I would do two things with this money, right? 75% would go towards girl child education. It's something I feel very strongly about, particularly in my country, where women are not always treated as equal, right? The remaining 25%, and this one's personal, and I've got a team member in the room, right? Coldplay is coming to Bombay for the first time. Tickets are sold out, so much so that there's a government inquiry into right, excessive pricing, because it's across every platform going through the roof. I have a 28-member team, right? They're getting, the 25% is going towards their tickets.
Well, good luck. Sounds like we have similar problems with concert tickets in the U.S. with a few bands we know of. But thank you for all of your time today. I think that's all the time we have for this episode. Thank you, Nisha. This has been a really great chat. And thank you to our audience for listening to this episode. Hope to catch you next time.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.